Well, good afternoon, everyone. Welcome to the Winter School 2022. We are in the, approaching the end of the fourth edition. Today we will have the third and last webinar, and we have the pleasure of having Professor Monica Correa. I will give a very brief presentation. Professor Monica Correa graduated in law and has a PhD in bioethics, where she developed her thesis on health data protection. Professor Monica Correa has a large professional experience of about 20 years, in the beginning as lawyer, then as legal advisor, and later on in several roles here at the University of Porto. More recently, Professor Monica Correa has been the data protection officer and member of ethics committee of the Faculty of Medicine of the University of Porto, and affiliate professor in the domains of bioethics and biolaw. So we have the pleasure of having a webinar about the rights to be forgotten regarding health data. So Professor Monica Correa, please, it's a pleasure having you as a speaker today.
Hello everyone. It's a real pleasure to be here in this Winter School webinar. I'm going to give a brief presentation about a right which is included in the GDPR. It was the subject of my PhD thesis. I approached this right from a legal and an ethical perspective, and I will address both perspectives in this webinar. I will share with you a PowerPoint presentation. This. So the subject of this webinar is the right to be forgotten regarding health data. This is actually the title of my thesis. I hope you won't be disappointed because we only have 40 to 45 minutes to address the issue and then have some time for some discussion. But I will try to go over the most important concepts to address this right. But first, just let me give you a little bit of context. In the second half of the 20th century and the beginning of the 21st century, we have witnessed unprecedented changes in all sectors of the global society. The area of health and medicine was no exception. The turning point perhaps coincided with the introduction of new technologies, both in the field of diagnosis, intervention, recording, and communication of health information. And thus, massive data collection became widespread and referred to as the big data era. This era is problematic due to the interface with a lot of new technologies such as, for example, artificial intelligence, quantum computing, robotics, which allow human-related data communication to others for various purposes, such as analyzing this health information. This reality challenges some of the fundamental principles of privacy, self-determination, minimization of data collection, consent, and the right of individual access. The challenge of privacy in this sense, we could say, is that, and above all, that of informational privacy. So, this context leads to the loss of control over personal data. Hence, in the European Union, the so-called right to be forgotten emerged. And what is this right? Is the right to obtain from the controller the erasure of personal information. This right is legally recognized in the European Union in Article 17 of the General Data Protection Regulation. And why does this right pose a problem in health information, regarding health information? Well, the question is that if you articulate the right to be forgotten with the ownership of genetic and health data and the values of privacy, identity, autonomy, and human dignity, this leads us to considering the right to be forgotten as a new paradigm. In other words, if in the past there was the discussion as to whom the health data belonged to, now the question of ownership having been resolved insofar as they are consensually considered to belong to the patient, the question arises as to whether their holder, the owner, has the right to forgetting materialized in the elimination of their data. So the right to be forgotten regarding health data poses really interesting legal and ethical questions. And putting our problem like this, we have to make some following questions. How do we fulfill the right to be forgotten regarding health data? Should it be done? And this is the ethical question, more than the legal one. So in this webinar, we will address the right to be forgotten regarding health data from 4 different perspectives in which ethical questions can be posed. If we explore the principles of autonomy, privacy, and human dignity regarding the right to delete genetic data, and we will I will address this particular question: why does this why the possibility of forgetting or erasing genetic data can pose ethical dilemmas? Explore the relationship of health data, privacy, data protection, and identity projection in the case of gender transition. Also, the ethical dilemma of the right to disclosure of gamete donors' identity in medically assisted reproduction techniques. And all this is related to the concept of privacy, which we will try to define. It is a rather complex concept, but if we try to define it, we will find a lot of features in this right, and we can address it as privacy and data protection, as identity projection, and as anonymity. So the question arises very strongly regarding these particular issues: genetic data, gender transition, and medically assisted reproduction techniques relying on gamete donation. And of course, the ethical analysis of this right wouldn't be complete if we didn't address the right to privacy versus the collective interests of public health. We have witnessed recently, we are living this reality in our society with the COVID pandemic. So it's rather important to address and complete this analysis considering public health issues. So to make a little bit of trying to define privacy, of course, we can address it as a fundamental right enshrined and in the Universal Declaration of Human Rights. and it is a pillar of democratic societies. Of course, everything we address in this webinar is, of course, relies on the values and principles of Western democratic societies. We can't speak about or talk about privacy in China in the same terms that we address it in Europe, or even in the United States, because they have a really different understanding of privacy, more restricted. They associate, Americans associate privacy with the right to have one's family and family life, intimacy and reputation and honor. In the European context, privacy is more linked to a sense of dignity, a sense of liberty. It's more wide than your reputation, your honor, your intimacy. But we will address this issue a little bit further. So privacy, of course, was emerged as a right, stipulated in the Declaration of Human Rights in 1948. But before that, the first article that addressed the issue of privacy in the law as a right was the right of privacy. In the 19th century, the end of the 19th century, it was a law review article published by the American jurist Louis Brandeis, the first one that really spoke about privacy in modern or contemporary ways. In this article was published in the Harvard Law Review. And of course, for the first time as a form of law, not really as law enforcement stipulation, but as a general guide for all nations to address in their legislation, we have the Universal Declaration of Human Rights, Article 12, which states that no one shall be subject to arbitrary interference with his privacy, family, home, or correspondence, nor to attacks upon his honor and reputation. Everyone has the right to the protection of the law against such interference or attacks. And of course, it's this definition that grounds the understanding, especially of American people, that privacy is related with honor and reputation. But this view evolved, and although privacy still can be seen in this way, it's much wider than this article really states. And of course, the other, a wider perspective of privacy and freedom is stated by Alan Weston in 1967. He defines privacy as the claim of individuals to determine for themselves when, how, and to what extent information about them is communicated. So here we can see that it's not about honor or reputation, it's about free will and your choice, your autonomy. Normally, or in a restricted perspective of privacy, we would say that it is related to your intimacy, your family life, and a restricted circle of persons and circumstances. But rather, in 1967, we can see that privacy is addressed as the individual's autonomy, the possibility to determine when, how, and to what extent information about them is communicated. It might not be private information. It might concern just something that he wants to project in one context and not in the other. For instance, I like to sing sacred music, and it's something that I share with a group of people, but I don't have to. It's not private in the sense of intimacy, but it is something that I cannot. I may choose not to share in my work environment. Or rather, I can choose to share it, but it's not really something that we can say that it is intimate or that can jeopardize my honor or reputation. So as you can see, the concept of privacy it is much wider than we can extract it from the definition of the Declaration, Universal Declaration of Human Rights. And something helped to change this perspective. Of course, we have what we can call a life dominated by big data. We have a lot of situations and data that can be shared with others and are not necessarily private when they are isolated, but taken together, they can allow someone else to draw a profile. And this is what where self-determination is more important, because before, only data that related to your intimacy were considered private. But in fact, if you connect a lot of individual aspects, not necessarily private, they will allow to make a profile, to draw and know your personality. Sometimes to know others can know a lot more about you than yourself, or than you would like to project in society in a certain context. Of course, there are some examples here that are not necessarily private, others are. But if you think about my email, of course, isolated is a contact. But if you have my email, my marital status, my age, my education, my voting habits, my political party, my income, my internet searches, you can draw a really, really clear picture of who I am. And this is the reason why some scholars study surveillance in a broad sense. David Lyon was is a well-known Canadian academic that first talked about surveillance in this broad sense. We were used to look at surveillance in the literally perspective, that is, in the video surveillance perspective. But surveillance is much more than that. It's as he defines it, any collection and processing of personal data, whether identifiable or not for the purposes of influencing or managing those whose data have been garnered. Surveillance has this double perspective or goal. Of course, for the academics that are concerned with privacy and identity and autonomy and self-determination, the law must be more restricted. It should regulate this matter in a really rigorous way. On the other perspective, there are people that see surveillance as a new form of intervention for law enforcement. It is decisive in law enforcement. It is seen as additional security, and of course, it is in the political agenda of democratic countries. If you look at privacy versus data protection, you can see that privacy, data protection, of course, can be related with privacy and privacy with data protection. But this is a rather, it is a young concept. In the 90s, the personal data concept was known by a restricted group of people and sectors that worked directly with this matter. So technological development, social networks, and so on, brought the personal data concept to the public sphere, and one of the paradigmatic examples of this is the Cambridge Analytica case. I don't know if you're aware of this. The Cambridge Analytica case was very, it was all over the news when it was discovered, and it gave a new global dimension to this issue. It was an investigation performed by the New York Times and the Observer. And they were able to prove that 50 million Facebook user profiles were used without the consent of the holders to identify and to influence, to determine behavioral patterns and for political propaganda. And it was proven that it was used successfully to influence undecided voters in the presidential election in 2016, which was won by Donald Trump. And this was proven. If you have curiosity, there is a very interesting documentary in Netflix, about 2 hours, on the Cambridge Analytica case, what happened, all the investigation performed, and other cases in which it was used but not really proven. In this case, it was proven, and it was really not that good for this company. But it is said in that documentary, although not proven, that Brexit was as well influenced by this company's work with our data without our consent. But you have here some reference. I will share the PowerPoint afterwards, so you can make your own research, and if you find this subject interesting. So, as you can see, privacy is a rather complex and multifaceted concept, because it is both a fundamental right, a personality right. It is linked to data protection, but is not limited to it. We can find its mark in the strict strictest confidentiality and intimacy, but it is also a condition of personal identity. It finds an echo in autonomy in terms of informational self-determination, namely through the right not to know and anonymity. So this is quite the point I was trying to make with this all this theoretical framework about privacy and talking about the Universal Declaration of Human Rights, privacy versus data protection, just a little bit of context to try and make you understand that this is rather complex, and it can take various forms. So if you think of privacy as intimacy, of course, it's privacy in a narrow sense, and everybody can understand that and extract it from various rules and regulations throughout national and international legislation. But in the sense of the informational self-determination, of course, it represents the right to choose what personal information may be disclosed and under what circumstances. And here I always say that it doesn't have to be embarrassing to be private. It doesn't have to be nothing special, but it is your choice to share or not that kind of information. And this self-determination issue is related to your own identity, the identity you project in context and not in other. Data protection, of course, is related to privacy, as its roots in privacy and in self-determination, of course, but it may concern private data or not private. If you think of your ID number, ID card number or citizen's number, it is not private in the sense to affect your honor or your intimacy, but it is rather a personal data. And of course, you can associate the privacy concept with anonymity, and which is, of course, one of the materializations of data protection. Identity, of course, it is related to data protection because identity is the development of the awareness of what one is. It is the dynamic representation process in one's environment. And that's why the right to be forgotten can be very, very important in gender transition. And we will speak about it a little bit further. Now, having this approach to the concept of privacy and data protection and this context of technological development that led us to data protection regulation more strictly and more widely in Europe, let us address now the particular case of health data. If you think of the right to be forgotten regarding genetic data, it is one of the most complex issues in the right to be forgotten. If you imagine you have a genetic test result, and the question you must pose is, do I have the right to erase this test? Because if you look at Article 17 of the GDPR, and I can stop this and make you, if you look at the Article 17, I don't know if you can see it, Article 17 of the GDPR, which is called right to erase, right to be forgotten, says the data subject shall have the right to obtain from the controller the erasure of personal data concerning him or her without undue delay, and the controller shall have the obligation to erase personal data without undue delay where one of the following grounds applies. The personal data are no longer necessary in relation to the purposes for which they were collected or otherwise processed. The data subject withdraws consent and on which the processing is based, according to points A and so on, or of this regulation, and where there is no other legal ground for the processing. The data subject objects to the processing pursuant to Article 21. This is not a case. Well, for our case, if you read all this article, you will see that the Article 17 doesn't explicitly prohibit the erasure of genetic data. You have the exceptions in number 3. Paragraphs 1 and 2 shall not apply to the extent that processing is necessary for exercising the right of freedom of expression and information. It is not a case regarding a genetic test. For compliance with a legal obligation which requires processing by union or member state law to which the controller is subject, or to the performance of a task carried out in the public interest, or in the exercise of official authority vested in the controller. It might not be the case if you make a genetic test in a private clinic. This is not the case. We could wonder if it would be the case in public hospital, but rather this is not the sense of this legal rule. For reasons of public interest in the area of public health, it is not the case, in accordance to points H and so on. For archiving purposes in the public interest, scientific or historical research purposes, or statistical purposes in accordance with Article 89(1). This is the tricky part here, is this point D, is that Article 89(1) established that for these purposes, public interest, scientific or historical research purposes, the right to be forgotten does not apply. If you think of medical research, you would say, okay, you can't delete genetic data if they are needed for if you have public interest or scientific or historical research purposes. Yes, that would be true. But the thing is that has to be done in accordance with Article 89 number 1, which demands that the data are anonymized. Well, that is something that is impossible to do with genetic data. Genetic data are the definition of identification. So this is rather tricky because it's apparently the rule covers all scientific interests and research with anonymization, but if you are not really careful, this rule allows for one to claim the erasure of genetic data. And why is that ethically problematic? Well, now this is my opinion. It is personal, of course, but I think it makes some sense. Since the human genome is the common heritage of humankind, genetic data are a repository of individual and collective identity, which is in this sense inalienable and must be protected. So the integrity of genetic data is an integral part of human dignity. Consequently, protecting each person's genetic data as a unique human being means respecting this uniqueness. Of course, one might say, okay, but since human beings exist, you will always have genes. So the genome will always be there. But the thing is, if you are able to delete information about your genetics, you might hinder this protection of this common heritage of humankind. Protecting the human genome is important because we are responsible for future generations. It represents deleting genetic information, represents in practical terms the defense of a right not to know as an absolute right, and all fundamental rights are relative. They have to be combined with other fundamental rights and have to be balanced with the proper proportionality principle. So if I take a genetic test, for instance, to see if I have propension for breast cancer, I have the right not to know the result, of course, but to delete it is different because my daughter has the right to know. So my genetic result is not only mine, because my genetic data are shared with other people. And this is what I believe it's not really taken care of in this provision of the GDPR. If we read it not carefully or not in an ethical perspective, we might have the right to delete genetic information, and that could be from an ethical perspective not really recommended. I would object to that from an ethical perspective. It would protect my right not to know in an absolute way, and that is not the case in fundamental rights. Although the GDPR establishes that special categories of personal data may be processed in identified cases, such as freedom of expression, don't have a right to delete if freedom of expression is the case in public health interests and historical, scientific, or statistical research, it is not clear about setting concrete limits to the right to be forgotten concerning these type of data. As a result, legitimate reasons for processing personal data may be questioned if individuals are granted the right to erase genetic and health information. Some family members may have interests when considering family claims to genetic data, and assuming there is a valuable pool of genetic data, they will have important interests regarding those results. So I think the law is still not sufficiently robust to accommodate family interests. And I suggest that an interpretation of the GDPR according to bioethical principles should be done. But the easiest way to solve this would be by the inclusion of a specific exemption concerning genetic data to prevent patients from claiming the right to be forgotten. That is my opinion regarding this matter. Okay, can you see it now?
Yes, we know.
So sorry, I thought you were I was sharing. I'm so sorry. I didn't one last just one click missing. Sorry. But this is Article 17, the right to erasure. You can download it from the internet. It's really easy. GDPR in English version, which is really I don't know if you have some participants that are Portuguese. It's better to read it in English because the translation is not quite accurate in some points. So it's better to read it in English, which is better. So here you have the rule that you can ask for the erasure in all these circumstances. For example, the day the subject withdraws consent. But then you have the exceptions, and when you look at the exception in number 3.3, you will if you look closely and to this, you'll realize that it's not really taken care the protection of family interests regarding genetic data. So let's go back to the PowerPoint. Okay, so this is the main ideas that I was speaking about regarding.
Excuse me, I think we have a question from Chris Obek. He's raising his hand.
Okay.
Please.
So my question is that for patients who have diseases that have genetic underpinnings like hypertension or diabetes, and they want to keep their information secure, safe, confidential without their relatives knowing, but some of these diseases can also affect their relatives, especially their close relations, like their children, their siblings. So if you are sharing, if the person does not have the right to have this information deleted, then that means that the person does not also have the right to the privacy we're talking about. But we say the patient has the right to whom he or she wants to share the personal information about health with. So wouldn't that defeat the purpose of privacy?
Well, if I understood your question, you are arguing that, of course, genetic result, if you have hereditary disease, that information is really important to your relatives. And that's my point. The point is that my genetic information is important to my relatives, my siblings, my daughter, of course. But the thing is that, as it is stated in the GDPR, there is no clear limit to the erasure of genetic results, because it is not quite in the letter of the law. The reasons would be for research purposes. It doesn't include in a very clean way the interests of family. That's why I think this law should be altered. It should be reviewed and should include that exception, so that relatives are not faced with the problem of erasure of information that can relate to them. I don't know if I was clear right now.
Yeah, so my question was in the opposite. I was saying that if that information, as it stands now, relatives cannot access those information, it means that we are keeping the patient information private, and the patient may not want to share with family. That is why he has not declared his or her genetic disease or susceptibility to other diseases. So if a family member also wants to know about his or her own genetic vulnerabilities, the person could go and also do a genetic test. So if such a thing is done, it means that we're taking the privacy away. And just to buttress the point, in a research where an information, maybe samples, blood samples or tissue samples are taken for a research, and the participant consented for it to be used in that research alone, purpose alone. And perhaps maybe several years later, the participants are dead or not alive, but the data is also important, could inform or better be used for other researchers. In this case, because they did not give consent to this new research, then the right to be forgotten should be followed and this data should be deleted. That is my view.
I think it's different questions that you're asking. The thing is, if you have the data, of course, you can choose to know or not to know. If I have, of course, a contagious disease, privacy will become seconded because my privacy cannot harm the health of others. That was what happened with COVID-19. But when we are talking about genetic diseases or propension to have a genetic disease, we're not talking about the disease, we are having a disease. We are talking about the possibility of having a disease. And I have the right not to know that. And my daughter has the right to know. What I'm saying is that if my results are erased because I claimed my right to be forgotten, she might have more difficulties in fulfilling her right to know. That's what I'm saying. And on the other hand, deleting information, genetic information, might hinder that collective right as members of the same species. I'm sorry if I'm not being clear, but I can't really understand very well because I'm not hearing you that much. And of course, this is in the European context, but it might have effects on other jurisdictions. For example, in the United States, they were really concerned about the right about the GDPR, because the GDPR might hinder some of the amendments of American Constitution. That's, for instance, the problem with the freedom of expression, which is really very important in the United States political and legal regime. So it's the basis, it's the foundation of their democracy. It's a little bit different than the way we see it here in Europe. But this is the main ideas that afterwards I will share the PowerPoint and you can see. And don't have that much time. With the right to be forgotten and gender transition, it's one of the interesting perspectives about identity, because someone whose gender identity was a problem in the past, someone with a gender identity issue that made transformation, might want to delete data related to that transition. If I don't identify myself with this gender all my life, once I make the transition, I would say it would be important to erase and to start over and to project my real me into society. So there might be a legitimate ground to ask to delete some of my data if I had a gender question. The thing is that such as with genetic data, this might pose some ethical problems. One of these could be, for instance, marginalization. We know for a fact that transgender people have unequal health care. So if we delete information about their health, this might be even more serious for their health. Another case is repentance. You can, which is also one of the ways you can exercise self-determination. And if you delete information, it might cause you problems. Of course, as in genetic data, the right to be forgotten in this case would make unlikely to screen genetic diseases, which is relevant to biological descendants. And medical records might be important for some types of research. For example, how certain health issues manifest differently based on biological sex at birth. Also challenges the principle of equality. For example, the selection of athletes in high performance sports. Of course, you don't have to have in your ID that you are transgender, but if you don't have medical records regarding that transition, the principle of equality in this for the Olympics, for example, could be a problem. Of course, other ethical struggles such as marriage, adoption, the inability to trace previous identity. So gender, although the right to be forgotten is aligned with the right to self-determination, there are ethical and legal questions to weigh in the deletion of gender information data. Of course, taking into account the principles of liberty and proportionality. I think that the solution would pass by international regulation, and of course some technological developments that secure this information and at the same time preserve the privacy of these persons. They are already vulnerable in society, so this is a issue that we should all address. I don't know if I can follow. It's 2 o'clock. I have I can share with you the some ideas with the right to be forgotten versus the right to disclosure of gamete ID. It's the problem of anonymity related to the purpose limitation principle, data minimization. But I guess we have to see each other next time and talk about, and of course, privacy versus public interest is more easy to understand that privacy should be in a second plan when we are facing public health issues. But then again, only when emergency measures are needed, not for all the time, with no schedule to erase this data. We have some conclusions here, but if you want to develop these issues, I have this published articles. It's in open access, so you can we can develop. If you have curiosity about these issues, you can read them, and of course I will be at your disposal in any circumstances to address these issues. Thank you very much for your attention.
Thank you very much, Professor Blanca Correia. Meanwhile, I have just a short question. To which extent do you think the general public is aware of their rights to be forgotten regarding health data?
Well, I don't think that people are really much aware of the GDPR. But since 2018, when the GDPR came into force, I guess people are more aware of the data protection issues because there is really high fines that can be that you have to pay if you don't comply with the GDPR. So in Portugal, this issue is rather, it's not really that new for us in our legislation, because it was rather advanced since in 20 years, but we didn't have any consequences if you didn't comply. So people were not very aware. This was a theme for specialists. But I would say that the right to be forgotten is people will be more aware of it. We have new legislation regarding recovered cancer patients, for instance, that weren't able to make a life insurance, and have bank credit to buy a house, for example. So and we have changed this recently in Portugal. So I think this right will be is in the agenda of the political agenda, and of course it is really important, but you have to balance it with other interests, such as scientific interests, research interests. So I don't think that it is rather developed, the connection between this matter in the health sector. In the health sector, not that much development, but in the because this was a right thought for the internet information, for the virtual information that the traces you leave in the virtual world. It was not the European legislator was not thinking about it to concerning health. It was concerning IT problems, and for instance, you have a picture or some information that is outdated in the internet, and you have the right to delete that information. But the thing is that, as it was written in the GDPR, you can apply it to health data, and there isn't much studied. My thesis is the first in Portugal about this issue regarding health, but I think that in the future it will be more developed, and I hope so, because it's important to balance all these rights.
Yes, so thank you very much, Professor Monica Correa, once again for your willingness to give us this webinar, your great presentation about this very important topic.
Thank you. It was my pleasure.
Thank you. So I think we could end this webinar. I hope to see you somewhere in the future.
Yeah, we'll see you. Certainly, definitely. Thank you so much for your attention.
Thank you very much. Goodbye.
Bye-bye.